Kulkarni, Assistant Professor, PGTD of Law, RTM in Puri University. Dr. Girish Kulkarni sir has been teaching as a permanent faculty in the department since October 2013. His specialization is jurisprudence and constitutional law. In addition to that, his areas of interest are administrative law, disability laws, human rights and duties, corporate laws, Indian Contact Act, etc. He is specifically working for realization of rights of persons with disability and accessible environment as per Convention on the Right of Persons with Disabilities. He has completed his doctoral research work in the rights of persons with disability under Constitution of India. He is also doing a research project on evaluation of the accessibility as a component of the equality of opportunity in all matters of education and public employment for persons with disability. He has also participated in various international and national seminars and conferences. More than 80 students have worked under him for their master's dissertation. Sir will speak on technology and evolution of privacy as a fundamental right. Over to you, sir. Yes, sir. Yes, sir.
Am I audible? Okay. Okay. Thank you very much, ma'am, for giving me an opportunity to share myself with all the participants here. I hope I'm audible to everyone. Uh, so we are already running behind the schedule. So I'll try to wrap up as possible, humanly possible to me, about the subject that we are going to discuss today. Good afternoon, all the participants. The technology and evolution of right to privacy as a fundamental right. This have an interesting anecdote that technology is an instance of interaction. Technology is an instance of interaction, of communication with each other. See, when the privacy evolves, we have to understand first privacy, then how privacy evolved as a right, then the scope of that right, and how this journey is being influenced by technology. With respect to private, the word private, if we look at it, the word when we look at the private, private means separate. The origin of that word is to separate, separate from ours and others. Something that we have is not we want to share with others. The origin arises to share and not to share. We want to separate these things. And when we want to separate, there is some reason behind the desire to separate what we want to share and what we don't want to share. So the desire of separation of our own from others is the origin, genus behind the privacy. Idea of privacy is not that recent, but its effectiveness is very recent. Even you have the provisions in a Telegraph Act during 19th century, which came in the 19th century, which talks about non-interference in the communication. But you can see the privacy has reached to the peak of its desirability due to the communication technology revolution. It is this revolution, the internet, the social media, the accessibility of communication even for a learned and non-learned person, even literate and illiterate person. Privacy arises its value, desire, derives value, and not only value, even the privacy gets its desirability from these technological inventions and evolutions. Look at how the privacy has been arose as a right in the human civilization. You consider that human civilization is always fluid one. It is not a one line, one-handed. It is not a. It's multi-dimensional. When you have a organized and accountable state, you find there is a more tendency of individual importance, because if we look at the history, we will find that many times the organized state is accountable, and many times an organized state is not accountable to the people. So whenever we found that the state, the power, the law enforcement machineries are accountable to the people, then you will find people tends to prefer individual interest over the collective interest. People, you will find that individualism prevails over the collective life of the society. And when individualism prevails over collective life of the society, what happens? Individual started to separate his own from the others. And then the demand of privacy arises. Privacy is a product of individualism. Privacy is a product of individualism. Either privacy is a moral stance, or it is a political philosophy, or it is an ideology, or it is a social outlook. But anyway, it is a part of individualism. We discuss how originates, how philosophically privacy has a relationship with individualism. How we do understand individualism? Here, an idea of an individual importance, his in autonomy, his liberty, and his rights. But the rights of an individual are irrelevant if he is living alone. The rights are relevant, important, only when he lives in a society. So when he lives in a society, there only question of privacy arises, that he want to share something and he want not to share something. That discretion of sharing the information about oneself with others, or privacy, can be identified as capacity of a person to control information about himself and to control perception about himself in the minds of others. Try to understand what just I say. It's a capacity of an individual to control information about himself and to control the perception about himself in the minds of others. So it is not so simple as it appears. It's a coil. Society has to play a role in ensuring right to privacy. In the absence of social participation, privacy cannot be secured. So first, I have told, privacy is a part of moral stance. Before addressing this point, I'd like to remind all of you, the historical jurist Sir Henry Mann, he has underwent a historical analysis of origin of legal systems and ancient legal systems around the world. He studied Indian, even Latin, Greek, then Babylonian, Chinese, many other ancient legal system he has gone through, and he comes to a conclusion. He comes to a conclusion, very famous one, that movement of progressive societies is from hitherto from status to contract. He want to say by this conclusion that earlier individuals are identified, their rights and liabilities are identified not because who they are, but because what status they have in the society. Are they belongs to any royal family, or any family having the watans, or any family having the particular status in the society? Even in a family, the status of the person decides his rights, whether he is a karta or son or the daughter, etc. See, this was very wrong and very was selfish system. No, this was a system evolved when the state was not sufficiently accountable to ensure the survival and the interest of the people. State was not accountable enough to protect the survival and interest of the people. That's why society evolved its own mechanism of survival. This may not be an ideal one, but at least they have evolved a mechanism of survival by the self arranging themselves. So status is based upon the social inclination of survival of an individual. On the other hand, when contract, the word contract which is used by Sir Henry Men, that contract symbolizes the freedom, symbolizes liberty, that symbolizes choice of an individual to decide for himself. The rights and liabilities of an individual will be decided on the basis of his own choices, not because of his status, not because where he has born, not because where he has placed, but because of his own actions. When we say his actions will decide for himself, their privacy crisis, because you cannot exercise personal freedom, personal autonomy, unless you have assurity that no adverse actions will be taken by others. Suppose a person want to exercise his choices, but he will be disadvantaged, he will be discriminated, he will be deprived of certain benefits because of exercise of choices. It is very obvious that his choices will be influenced, limited, restricted. So what is the use of it? The use of it is that once we are able to encourage the liberty of an individual, then only we will able to ensure privacy of an individual, and vice versa. If we are able to ensure privacy of an individual, then and then we can exercise liberty of an individual. So where does privacy originates? It originates from an individual autonomy. Individual autonomy gives rise to the personal privacy. Now, just I have told you what is privacy. Privacy about a person is a capacity or ability to control information about himself. That may be textual information, any kind of information, or to control the perception about himself in the minds of others. So, what information I want to share with others, that may be also different. I will like to share a lot of information with my friends, but that may not be true that I will share all the information with the students. Or some information may be shared with the students but will not be shared with the friends. This choice depends upon the individual, but it has a hindsight. Other side is that when there was a collective life, society was also responsible for the welfare, protection, and interest of an individual. But when individualism will be prevailing, society will not be able to held accountable for the welfare, survival, and interest of an individual. Means now individual will lose the social protection. And when individual will choose to leave social protection, only in a framework where the state is able to protect the interest of an individual. So, privacy is a kind of shifting accountability of an individual interest from society to an organized state. In addition to this, I just have said it's a political philosophy or it's an ideology or it is a for uh, philosophy, ideology, or it is the stance. It is a kind of mechanism by which individual can exercise his choices. Further, if we'll go, that after considering that you can find where we want to exercise individual autonomy or liberty, we can trace its existence in the constitution, that is article 21, personal liberty, even the freedoms under article 19, or even the political ideology which prevents the discrimination, that whenever a person is exercising his liberty or exercising the privacy, he should not be discriminated. He should have the choices of the sexual orientations. He should not be discriminated. All the rights are organically connected with each other, and that's why privacy is a product. It's a product of, though it is not expressly mentioned in the constitution, it's a product of multiple rights. When the constitution was under framing, at the time the question was raised, look at the impact of technology on the privacy here. The question of privacy was raised in the assembly, saying that we should ensure privacy as a fundamental right. Not in the same verse, the verse was different. Definitely, Aladi Kushner and there are many others who has referred the matter before the assembly, but it could not have secured. There was lawyers, of course, and there was lawyers, so they have drafted a very clear, lengthy provision for it. They was saying that we should give protection to the individual communications, documents, his home and his records, and etc. etc. Um, but the matter went to the voting and who could not secure its place in the constitution because B.R. Ambedkar have already said that the same provision is already there in the CRPC. Look at the nature of privacy they have discussing. The privacy they was discussing was only related to the civil or criminal proceedings. That was the limitation of the understanding because only that was the relevant matter for them. There was no personal privacy. There was no interpersonal privacy. There is no privacy of a data. There is no privacy of a communication, virtual communication. There is no privacy of your location because that was not present at the time. That's why I told you why all these things has been consistently important today because of the evolution of technology. We have multiple cases throughout the history who refer the matter of privacy in the Supreme Court. But the significant case that has been challenged and that has been decided by the Supreme Court about the privacy was Puttaswamy. Why? Because it was related to the privacy of biometric information of an individual. Unless and until it is established that information of an individual is secured constitution, by fundamental rights, you cannot control, you cannot limit the access of the state to the individual information. Only fundamental rights can prevent the state from accessing the individual information. The biometric information is an individual information. An information used to identify a person. See, if we start with, means if we want to trace in the modern legal system the origin of privacy, we can find in the Article 12 of UDHR, which speaks about no interference in the privacy, family, home, and communication. Article 17 of ICCPR, which speaks about almost the same identical provision. But these rights was not sufficient, so it comes with a commentary. Now, in the commentary, the UN body has made a distinction between positive and negative application of privacy to the state. Mind well, the limitation of human right document is that all the documents held state accountable for the individual. But it does not consider does states are so powerful and so capable to make the social change. We are living something very precious here. Society cannot be changed, human right cannot be ascertained just by the state mechanism unless and until we are able to interact with the social mechanisms. That's the precise problem. The whole human rights jurisprudence is lagging here, that we do not provide any mechanism of social interactions. We shift that burden to the state or NGOs and or the bodies, but it's still a problem. That's why we know in the 70 years, many issues are not yet solved, uncertain. Many issues are yet unrepresented as well. Privacy ensure a human to be itself, to be itself or himself or herself the way they want. This is a basic right of an existence of a human being. In the MP Sharma versus Union of India, it was categorically rejected. Kharak Singh versus State of UP, you might be aware about the case laws. It's a very interesting development. I'll not repeat the whole case, but see, Justice Subbarao was the person who identified relative importance of this right. We are talking about when it is right to privacy does not come with isolation. There is always conflict of freedom of information of others and right to privacy of an individual. The society have a right to know about you if the society wants to participate in your life. And at the same time, you want to live alone by the society, by your privacy, and at the same time, you want to participate as a member in the society. This is a conflict. Conflict, I repeat, the conflict is society wants to know about you if you want to exercise your right to participate in the society. And if you want to live alone from the society, you can exercise your right to privacy, but you cannot exercise the right of participation. This precisely happens. This precisely happens with the social media. What is happening? Unless and until we press the I agree button, no participation in the social media. And if you want to exercise your privacy, you have to compromise participation. And if you want to exercise right to participation, you have to compromise the right to privacy. This is the real conflict. And we have to come to a resolution, a legal resolution, how to balance these two rights, to participation and right to privacy as such. Look at where are we going in our technological innovations. The data storage is increasing, the volumes are decreasing, processes are getting faster. To an extent, this development will go, but the manner will not change. New innovations are being made. The quantum computers are there. Even they have the DNA storage. We are working on technologies like Neuralink, where there will be a card inserted to a brain. After 50 years or so, no need of card will also be there. The softwares can directly upload it to your brain and directly download it to your brain. Are you getting where are we going? Can we have privacy in this changing world? Does the world really exist the way we perceive it? Or there is alternate reality in the form of virtual world we are creating today? And when there is an alternate reality that has been created, who do have a right to privacy? The alternate personality on the alternate world, or the person who are living in the real world? Are we separate? Are we one and the same? These questions will be raised in the future. The question whether we as a person on the virtual world have a right to privacy, and we as a person in the real world have a right to privacy. Children have a right to privacy. These are the challenges. The AI technology, we don't know what is the future. Are they going to create a artificial conscious? And if the artificial conscious is created, where it will learn itself, and when it learns itself from the behavior of real persons, can we say our privacy is broken? We don't know. We can come to a very temporary solutions that we will use the less technology, will you depend less upon the artificial intelligence, but might well. The same dialogue was going on when the 25 years ago that we don't need mobiles. Mobile is an artificial need created by the market. After 25 years, can you imagine a day without mobile also? Is it only creation of a market, or market has provided solutions to the desires of human being? So does privacy has to be compromised for the desires of human being, or the privacy has to be considered as a non-waivable fundamental rights? You might know the doctrine of waiver. Rights cannot be waived. Though you entered into a contract to waive your rights, still your rights will not be waived. Can this protection be granted to the right to privacy? In Puttaswamy, you know, the Puttaswamy has referred earlier cases, R.R. Gopal versus state of Tamil Nadu, where Jeevan Reddy has said that once you surrendered your right to privacy, you cannot reclaim it. In the Auto Shankar case, they said once your data is in public domain, the records are in public domain, you cannot control the flow of information. You have surrendered. But now new questions are arise In the case of Putra Swamy, once right to privacy is considered as a fundamental right, thus one cannot say that my privacy cannot be waived, though I have surrendered it. Cannot be taken away from me. So new questions, new constitutional questions, new legal questions are also emerging. The questions about data privacy, and these are the huge issues. The technology is changing beyond imagination before we made a law. Still, that's why we are not able to frame a law and legal system in this country for the protection of data as such. There are a lot of issues to discuss. Multiple things are there. But the conclusion that what is privacy? I just wanted to draw your attention to the technological influences upon the evolution of privacy as a fundamental right. We have to answer a question: does privacy is a fundamental right? Second question: what is the nature of fundamental right? Third question: what are the limitations on the fundamental right to privacy? Whether right to privacy is a primacy will be given primacy when it will come into conflict with other fundamental rights? Answer is no. In PUCL versus Union of India, I repeat, what was the question? The question was, does privacy will be given primacy, superiority, priority over any other fundamental rights when it will be given come into the conflict? Supreme Court held privacy of the information of criminal antecedents or the financial data will not be given priority when a person is voluntarily contesting an election. His privacy is overshadowed by right to information of the people about the public figure. Same, if you look at when there is a conflict between right to privacy at one hand and right to lead a healthy life at another, which right will be prevailed? Right to live a healthy life, which will be prevailed. In the case of X versus Hospital Z, when there is a test conducted by a boy, he was found HIV positive. The report was disclosed by the hospital to the fiancé of X, due to which the marriage alliance was broken, where H was claiming that my confidential communication was broken by the hospital. Consumer Forum rejected the claim. Supreme Court held that yes, it's the breach of hospital and patient confidential relationship, but that breach is not illegal because that breach is in order to ensure right to live a healthy life of the individual as such. That's why we have to consider whether right to privacy will be able to be secured in the technological future or not. The changing technology is the reason as well as is the evidence of threat of individual privacy. Mind well, mind well, the challenges of privacy are going to continue in the future because the future is itself uncertain. What will happen if we are going to upload and download the skills of human in a human brain? What kind of privacy will be talking about then? And we are not very far from that future. Just it's a matter of few decades or few centuries, we don't know. So does privacy exist? And if it exists, what is its nature? And does its nature is influenced by technical innovations? The answer is yes. The nature of privacy depends upon the nature of reality existing in the technological world. If we are able to disassociate ourselves from the virtual personality, then the virtual personality will able to secure its own privacy. Answers has to come from the technology itself, and the questions will also be asked by the technology itself to the privacy. With this, I think already I am being exceeding the time limit. Anyway, uh, I'd like to answer the questions if anybody would like to ask. Hello?
Yes, sir. Yes, sir. Sir, Mr. Chetan's question is, should the extent
Hmm.
of judicial intervention in controlling individual autonomy be limited as the very nature of individual interest should be absence of any kind of intervention? So his question is because we are think that the judiciary is entering into a core private life of an individual. That's why he is asking this question. May I repeat the question, sir?
Yeah, please pardon.
Yes, sir. Sir, his question is, should the extent of judicial intervention in controlling individual autonomy be limited as the very nature of individual interest should be absence of any kind of intervention?
Uh, exactly. He's saying about the two
उस
things.
वाली जो अलमारी है ना, वो जो है
Hello?
सामने वाले अम्मा के
Hello?
कमरे में, जो हवा
Please,
Hello?
please, please,
Am I audible?
Ms. Navjot, please mute yourself.
Hello?
Yes, sir.
Am I
Yes, sir.
audible?
Yes, sir. You are
Okay.
audible, sir.
So I was saying the question appears to be in the two parts. Number one, whether the ability of judiciary be limited to intervene in the individual autonomy or to control or to limit the individual autonomy. And for the sake of protecting the individual interest, you are saying. Am I correct in understanding the question? Hello?
Yes, sir. Mr. Chetan.
So, okay.
Sir,
So,
am I audible, sir? My question is
yes,
very
yes, yes.
specific for the reason that we are nowadays
Mhm.
seeing that the judiciary is intervening in the core private life of an individual. And therefore, as you rightly explained, sir, that individual autonomy is what is to be protected. So, if individual autonomy is to be protected, what should be the extent of judicial intervention, or should there be at all an extent of judicial intervention or not? Should there be a rider or not? Is
Okay.
my question.
Okay. So, about the rider, you are saying, so the limitation on, I like to quote a very interesting lines by Professor Rouse here. I think these lines able to answer your question. He said, there is a limitation on liberty. There is a limitation on liberty. But what is that limitation? The limitation of liberty is the liberty of others only. Liberty of others is the only limitation on the liberty of an
Okay.
individual. Are you getting?
Yes, sir. Yes.
So personal autonomy need not to be intervened to an extent it is not going to influence the autonomy of others. The moment it start interfering, I think we have to bring in the state machine.
Okay, sir. Okay.
Okay, thank you.
Thank you, sir. Thank you very much.
Sir, next question from Rajiv Girnikar, sir, is
Yes.
how right to privacy will be preserved in the changing perspective of technology?
So he's asking about two things.
How we can preserve
What in
our
what
privacy
man?
rights?
Yeah, right. So, firstly, there is a changing technological innovations and changing the whole world. Realities are changing, and whether in that changing reality of technology, can we protect our privacy? See, protection of privacy evolves out of a desire of controlling the information about oneself. That's why I told you it's a balance, not only to be balanced by the state or the legal system, but even by an individual. It's a balance to be protected. See, for example, uh, some things we can control about ourselves, like we want to impress others by sharing that I have visited Switzerland, and we posted the photographs. That's why one of the high court has to I think give the that you should not post the photograph in the children, because they may be adult as saying that you have violated their privacy. But at the same time, that's why I told you, you desire to participate in the social life, to influence others or to be influenced by others. If you do not share the information, you will be left behind from the participation. Answer to this is that unless and until the legal framework is matured enough, that suppose I want to share a photograph on social media, still nobody will able to use that photograph without my permission, directly or indirectly. I will be the owner of it, not the. So these are the issues. That's why I told you law is yet to mature. Today we can say that we are only in a stage where we will expect that privacy exists and some legal remedies are available, but yet the system has to get matured. Hello, am I audible?
Yes, sir. Yes, sir. Sir,
Okay.
the last question from Dilip Kumar Pareda, sir.
Okay.
Uh, the Supreme Court has recognized the right to privacy as a fundamental right. Sense of a proper legislation, how a person will seek its enforcement, whether every time one needs to approach the court in case of privacy by a third party.
Uh, See, it always happens. No fundamental rights gets so moto implementation, because we required a mechanism of enforcement. Yes, to some extent, the see, as we know, when was talking in the jurisprudence as well, every decision of Supreme Court has a 3D value. 3D value, the means it is binding, like Puttaswamy case, it is binding on the parties. Means in the case of Puttaswamy, on the Puttaswamy and the Union of India, it is also binding upon the courts. Means whenever new cases about this nature will be there, there will be similar decisions. But most important, the executives has to take note of the changing law and act accordingly. The problem of judicial legislation is that we don't have a mechanism of enforcement of the judicial decisions directly through the bureaucracy. There are some rare examples, like we have Vishakha, and we have some guidelines related to the blood transmission. We have guidelines about the foreign adoptions. Other than that, the judicial decisions, by and large, for the general public, gets very difficult to enforce. And when we are talking about a general concept of privacy, I think it is very difficult for a general enforcement of right in the absence of statutory law as such, because we don't have the guidelines, general guidelines, and the court are always saying privacy is specific, case specific. We cannot decide a general guidelines of privacy, and unless we get it from the Supreme Court, I think judicial remedy is unavoidable.
Thank you, sir. And one more question from Vinay Borkar. His question is, right to be forgotten will be prevail or right to access if it's on internet, like case law. If accused is free case but still is there on internet, so what will be prevail right to be forgotten?
So you are talking about the two things. One is right to be forgotten on internet, and second is right to access the information on internet. Okay, both of the we are being here to make riders that on internet only. So here, to some extent, I think in the High Court of Bombay has made a decision that right to be forgotten can get a priority vis-a-vis the general right to information. Not specific. What is general right to information? Anybody XYZ will make a type on Google and will try to find out. But specific right to information means you are filling a government form, or you are seeking an admission, you are seeking you want to contest elections. You cannot you cannot claim right to be forgotten over right to know. So in that case, I think right to be know or right to be known will prevail over right to forget. So that's why just in the case I just in the Gopal in the RR Gopal versus state of Tamil Nadu, Justice Jeevan Reddy has very rightly said, right to privacy is an interstellar and penumbral right. It is uncertain. It has to depend upon case to case, very uncertain, because it's a relative right. It always relates with any other right of others. So I think that depends upon the circumstances in which the right is claimed.
Thank you, sir. Thank you so much.
Thank you very much.
Thank you, sir, for your valuable time.
Thank you all of you for
accepting our invitation on last moment, sir.
thank you very much.
We
It's
have
my pleasure to share some of my thoughts upon the topic. Thank you very much.
yes, sir. On behalf